I'll give them a few more minutes. Midland Credit Management Incorporated versus Lori Hitt. This is case number C20 G5727GC.
Good morning. J. Baig, B-A-I-G, P36820, appearing on behalf of plaintiff and the attorney of record.
Defendant here.
Yes. Lori Hitt.
All right, Ms. Hitt, are you in a safe location?
A safe location?
Yeah.
The library, the university.
Okay.
You hear me?
Yes, I can hear you. It's just last time we were here, you said that your neighbor was, I don't know, having marijuana smoke.
Yes, it was all kinds of problems at home.
It was blowing into your apartment,
yeah.
And you were feeling as though you were becoming intoxicated from it.
Yes, it is affecting my health.
That's why what?
Yes, it's been affecting my health for quite a while. Yes, I'm at the university and the library. Okay. I don't have internet service at home.
All right. So I think today it is up for the plaintiff's summary disposition motion. But have you guys had a chance to discuss this?
Your Honor, we've had several hearings. Today, no. If she's willing to try to discuss settlement, we can discuss that. If she's not, then let's just go ahead and proceed. We've already had several hearings on this case.
Well, ma'am, are you wanting to go in a breakout room and talk to him?
No, there's nothing to discuss. I put it all in motion to dismiss. I'd like to
file a motion to dismiss?
Yes, I did. I sent them a copy and you a copy. And I don't have any
all right.
I don't even have an income. They're not allowed to garnish Social Security wages, which I haven't even started receiving. I don't understand why they are trying to use me as some kind of a precedent so they can take advantage of everybody that aren't able to pay their excessive fees.
All right, well, listen, this is what I'm going to do. The motion for summary disposition, I think, was filed. Who filed theirs first? You filed your motion to dismiss on January 17th.
We noticed ours for on December 10th of 2021.
Okay. Well, I'm going to hear the summary disposition motion first, and then the motion to dismiss. So, Mr. Baig, go ahead.
Your Honor, this is a motion for summary disposition brought under C9, C10. Basically, the defendant's position on this is that the filing of the lawsuit is somehow harassing her. Arguments don't make sense in this regard. But in any event,
wait. I want you to address your motion to summary disposition. I can ask you to talk about your response to her motion in a minute, but let's just, make it, I've got two different motions.
Okay, I'm going to make it. I'm going to make it brief. I think our written motion, brief, and exhibits are substantial. I'm going to pretty much stand on that, but I'll say this: we've shown the chain of title. We've documented our case with account statements and other documentary evidence. She has not, in her response, provided any documentation refuting our documentation. Actually, since we submitted it, our documentation, as per required by the court rules, then the burden is on her to show documentation to the contrary. She can't rest on her mere allegations, and that's what she's resting on. She's arguing that somehow Midland Funding does this and that.
Wait, Mr. Bay, you're mixing the two things here. That might be a response to her motion to dismiss. I want you to tell me about why you feel you're entitled to summary disposition, and since when is there a shifting burdens situation?
Assuming that we met our burden, which I would argue we did. There is the brief outlines the legal basis for our motion and why it should be granted. With regard to documentary evidence, we submitted account statements that show payment and purchases made by Miss Hitt. Let's see what else. There is a I don't believe she's denied ever using the card. There's affidavit of account. Bill of sale assignments. Letters sent to her before the filing of the.
Wait, Mr. Bay. She says in her pretrial questionnaire, the first sentence under factual statement, I have never used a Capital One store card for Walmart, nor was issued a card as I believe was promised before the unforeseen circumstance and blah blah blah.
The answer is immaterial because discovery was sent to her, including requests for admissions, which she didn't answer. So the requests for admissions are deemed admitted, and they override anything that she's alleged in her answer. Those are also attached as an exhibit. So based on all that, we're requesting that our motion for summary disposition be granted.
Okay. Ms. Hitt, what do you have to say just on the motion, your response on the motion for summary disposition. And then we'll get to you making your argument about your motion to dismiss.
I don't see why they're pursuing this when they're not. I don't have an income for them to garnish. And I never was issued a credit card for Walmart from Capital One. And I don't know what questions it's talking about that I did not answer.
You don't know what you don't know what he's talking about?
Some questions that I did not answer. I don't know what he's talking about. And several other things.
They say they sent you during discovery a request for admission. A list of questions, where you were to deny or agree with the statements made.
I never used the card. He just misrepresented right there. I never used the card. I never got a card.
Okay.
And he's, with all due respect, he's completely twisted around the circumstances about my requesting documentation about their bill of sale for purchasing a debt from a creditor when I'm claiming unjust, what is that called? Unjust rewards. Well, how can I defend myself if I don't know how much they paid for an account that's already written off for insurance and tax purposes? And they're all the lawsuits are saying, even the Supreme Court is saying how sleazy, quote, the word sleazy, the debt buyers are on them, Midland Credit Management and their affiliates.
Wait. What Supreme Court said that Midland Funding's debt buying practices were sleazy?
I don't have it with me.
Well, ma'am, this is the day to argue the motion. Come on.
How can I defend myself when they won't provide me proof of how much they have paid in order to collect all this money? They shouldn't be able to collect a 5,000% profit on something they paid pennies on the dollar for.
Why would you say that?
If they
Why
paid,
would you say they're prohibited? Wait. Why would you say they're prohibited from doing that? Because the fact is, they're not prohibited from doing that. People can buy and sell debts. And when somebody buys a debt, they have it, provided that it's within the statute of limitations, they have the right to try to collect it. That's how they make their money.
There's a limit on how much interest you can charge on an account.
That's true. But I don't know if we're talking about, when you say the account, are you talking about when it was still a credit card or, what point are you talking about? When it becomes a court judgment? I mean, yeah, there are limits.
Well,
interest is different than how much they paid for the debt, and whether or not they're allowed to make a profit when they bought a debt that they're allowed to collect on. So, okay. Anything else?
Just they absolutely have violated the Fair Debt Collection Practices Act in all the ways possible.
Okay, let me ask you about that. So are you going to be presenting evidence that they violated the Fair Debt Collection Act as it applies to your case?
My testimony.
Ma'am, I'm asking you something really more specific. Look, we could say for example, that Ted Bundy is a mass murderer and a bad guy. He was a mass murderer or a bad guy. Now, if there was somebody that died or was murdered, you know, you'd still have to prove that Ted Bundy murdered that particular person. I mean, in other words, you know, the fact that somebody may be a bad character or they may have practices that you don't agree with, you got to be able to show some linkage between that particular type of behavior and how it might apply in your situation.
Well, all you'd have to do is go online and check their court cases, their the Better Business Bureau has 4 there's class action suits against them. My testimony is just as good as any other third party as a witness.
I don't know what that means. What does that mean?
My testimony is just as good as any other witness. If they
Well, let me ask you this. Yeah, there have been lawsuits and class action lawsuits. Are you a part of any of the classes?
No, they're also very
as plaintiffs in some of those lawsuits?
They're also very rude to me when they call. They're aggressive. They speak so fast. I have had a robocall. I looked at my phone. I thought I hung up on him. He did a robocall to me and hung up on me. That's a violation. Under no circumstances should any type of business, such a large corporation, be disrespectful, talk down to me, and demand me to pay money on a phone conversation. And I can't even see where I'm at with all of this. You're not really allowed to talk back to them to describe your situation.
Well, ma'am, let me ask you a question. Or a couple of questions, if you don't mind. Let's say I go down to, I don't know, pick a bank. Chase Manhattan Bank. Or whatever. I go down to I'm not going to name a bank. It doesn't matter. Let's say I go to the bank. I go to a bank and I borrow $1,000. And I agree to pay the $1,000 back, because it's a loan. And let's say I go to that bank one day and for something that doesn't have anything to do with the loan, or maybe I'm over there to make a payment on the loan. If the teller is rude to me that day, You know, let's say the teller's like really in a bad mood and is really rude to me. Okay. Does that mean that I'm not obligated to pay the loan back?
Well, I discussed it before how I paid them thousands and thousands of dollars.
No, ma'am, I'm asking you, I'm not asking you about your case. I'm asking you in the context of this hypothetical. Because it sounds like what you're telling me is they're a big corporation that's rude and nasty, and they violate the federal debt collection law. So therefore, I'm not obligated to pay the money back. That kind of sounds like what you're saying.
Well, that's just one of the things.
Okay. All right. Well, let me ask you a question, man. If you're alleging that they violated the federal debt collection laws as it applies to you, is that right?
Sure.
Okay. All right. So did you file a counterclaim in this case? Or you just basically said you're using that as a defense?
It's my part of my motion to dismiss.
Okay. All right.
Your Honor, this is the fourth hearing that I've been on for this case. You advised her to seek legal counsel. For some reason, she hasn't done it. Bottom line is that, even without the documentary evidence and everything else that we presented, she did not answer the requests for admissions. They are deemed admitted. They're just deemed admitted. She has admitted to every essential element of this case. Our motion must be granted.
She says she never got them. That's what she just said.
Well, there's a proof of service. She claims she never got the account statements. If you take a look at the account statements, take a look at the address. Same address as on the notice of hearing.
I don't even know what he's talking about now.
What's the date you sent the request for admissions, Mr. Bay?
Proof of service, which is in the motion for summary disposition, September 16th of 2021.
Could you please say that date again?
September 16th of 2021.
I received 3 summons. Is that what you're talking about? Is that what he's talking about, Judge Marable?
The request for admissions, interrogatories, and request for productions of documents, as well as the plaintiff's second pretrial conference questionnaire and the 67th 5th District Court pretrial questionnaire form were mailed to the defendant on September 16th of 2021. Now we're about 9 months past that date. She didn't answer the admissions. She didn't file any objections within the requisite 28-day period. They're deemed admitted.
Well, did you receive them, ma'am?
Receive which thing?
The interrogatories and requests for admissions. back in the fall.
Admissions for what?
2021.
What would I? What admissions for what would I admit?
And then to top it off, Judge, hold on, Judge. And then to top it off, she received another copy of this as part of our motion for summary disposition back in December. Still no answers. They're deemed admitted.
Answers for what?
You instructed her to get an attorney, Your Honor, on more than one occasion. She didn't do so for whatever reason. She has no excuse for not answering the discovery.
Ma'am, did you try to get a lawyer on this?
Yes, of course I spoke to the legal services. I can't afford an attorney. I have a legal constitutional right. What right do you have to order me to get an attorney if I'm a citizen of the United States?
Your Honor, she says that she does
ordered you to wait. Hold it.
She says that if you would please just stop being obnoxious to me and intimidating me. You're violating my Fair Debt Collection Practices Act right now, the way you're speaking to me.
Your Honor, she says she's on Social Security.
I did not say that. You're lying right now. I did not say I'm on Social Security. You can't even keep your story right. You want me to send you a check for money I don't owe you. And you think that smirk on your face, you just think I am a joke.
There's no smirk on my face. Your Honor, please rule on the motion for summary disposition.
The motion for summary disposition is denied.
And just so that we have a record for purposes of appeal, can you please articulate your reasons?
There were issues raised in your argument that are fact questions. You argue that she didn't indicate that she didn't receive the credit card or not, or didn't, let's see, how did you put it? I can't remember exactly how you phrased it, but I pointed out in her pre-trial questionnaire that she denied. Yeah, that was it. You said she didn't deny having this card, and that the burden was on her. I disagree on that, but
the request for admission say otherwise.
She specifically did at her pre-trial questionnaire deny using this card or being issued the card. So that's a fact question.
Your Honor, just so I establish a record, the request for admissions, which she didn't answer when they were originally served and when they were put forth as an exhibit to the motion for summary disposition, they're deemed admitted. They override her allegations in her answer or any defenses that she raised in their answer or in her pretrial questionnaire.
If he is saying that,
well, I didn't, Mr. Bay, it's one thing to say, it's one thing to try to make the argument that, first of all, let me see the dates on the pretrial questionnaire. When did you file your motion for summary?
In December of 2021.
Well, her pretrial questionnaire was when? When was the pretrial questionnaire filed, ma'am?
I don't have that with me. I believe I did. I think you told me I had to send. I've sent 3 different things to. One to the court. The clerk told me I just needed to start out sending that, and I did send answer to them, copies to you and to them, and then I did the motion to dismiss.
It was filed September.
I have papers
And
everywhere.
when did you send the request for the interrogatories?
They were served September 16th of 2021, and then also included as an exhibit to the motion for summary disposition, which was filed in December of 2021.
Well, you filed it after she filed her questionnaire, so you know the timing doesn't work out for you, Mr. Bay. It works in the opposite direction.
I would disagree, but that's fine. I would just put my disagreement and objection on the record.
That's fine, but I mean, you know, the court got her questionnaire early September, like September 3rd. You're filing your motion for summary and your interrogatories. See, this is why I don't do discovery. This is why I don't hear SD. This is one of the reasons why I don't hear SD motions until you know, the close of discovery.
Well, Your Honor, you just said that you received a pretrial question. Your Honor, you just said that you received a pretrial questionnaire on September 3rd. The discovery that we sent is after that. So her failure to answer the request for admissions override what she has stated in her answer in her pretrial questionnaire. They post-date that.
Well, I think it's a fact question. So, you know, at the end of the day, I don't care, you know, listen. At the end of the day, you got to prove that you issued the card to her and that she used it.
You don't have to. The request for admissions, which she didn't answer, admit to those essential elements.
Okay, well, there are fact questions. That's just one.
And I would object. There's no fact questions. The request for admissions override all that. There is no question of fact remaining based on the request for admissions.
I don't even know what admissions he's talking about.
Well, ma'am, that's because you want to represent yourself.
I don't want to.
Well, yeah, you do. Because, yes, you do. I think that we provided the information for legal services and the Bar Association lawyer referral service. Did we not provide that to you?
Well, I don't have any choice if I'm summoned into court. I don't have any choice. I don't have any choice.
You're ignoring my question. You're ignoring my question. I mean, we provided to you some possibilities for you to get a lawyer for free or very cheap. So, you know, you made a point. You said nobody can order you to go get an attorney. And you're right. Nobody can. I can tell you all day long that I think you'd be better served and have a better opportunity to make your best case if you had a lawyer. I mean, there are lawyers who do defense in this type of case in this state.
Well, it seems to be a lot of them.
but you decided, I mean, I don't know what you decided, but for whatever reason, you're representing yourself. So, you can't, I mean, it's almost like you want to have it both ways.
Well, the big complaints are they think that they are entitled to people's money when.
That has something to do with you getting a lawyer or not, man. They're going to do whatever they want to try to do. They're going to do what they usually do. That has nothing to do with whether or not you get a lawyer to help you defend yourself.
They know people can't protect their rights.
Well, as a practical matter, I understand what you are saying. And I will even say that I don't know the arguments that you are making probably in a global sense have some merit, but being able to apply that to this particular situation and bring it down to this particular situation, that's what's going to have to happen on your side to be able to prevail. And probably having an attorney that does this type of work, and there are several, will probably be able to help you. But, you can't complain about, I don't understand what's going on. And then on the other breath say, well, nobody can make me get a lawyer. I mean, nobody can make you understand either. So what do we do with that?
Well, I can't pay more to an attorney than what a debt buyer expects me to pay to them. That wouldn't make any sense.
I agree with you. I mean, well, let me say this. I understand what you're saying. And there may be, as a practical matter, I think people do make that kind of calculation. On the other hand, maybe it makes, on the other hand, they're probably expending more to collect this debt than what it's worth to them.
I don't see how a Zoom conference would cost so much money.
Well, Mr. Baig is covering it for the attorney of record. So they got to pay him.
Somebody should pay me. Well, if you dismiss the case, they're not going to pay me for my time, my anguish.
It doesn't work that way.
I see.
I mean,
I have some of the.
Okay, well, I'm denying a summary disposition motion. The motion to dismiss. I am. The motion to dismiss is denied at this time. Now, ma'am, if you are able to perfect the motion by connecting the dots, so to speak. If you can connect the dots to say that these things that you're talking about in the broad sense that these folks are doing, that they did it to you, and that by law you're entitled to a dismissal. If you can connect those dots together, you certainly can make another motion to dismiss.
Well, how would they be able to keep following through on this if I don't have the income? They're not allowed to take my Social Security when I receive it. And I wasn't aware they were supposed
to. That's more of a practical matter, isn't it?
They can't collect on it. They're not allowed. Why are they doing this to me? And I wasn't aware they.
The judge. Listen, ma'am. If they got a judgment against you, it would be good for 10 years, and they could ask for it to be renewed for another 10. So you might be on a income, where you're getting disability or something that they can't garnish now, but there's nothing to say that, you won't hit the lottery or come into some money or, anything could happen. I guess maybe that's what they're thinking.
I wasn't aware they weren't supposed to be accepting money from student distributions either.
From what?
Student distributions, the creditors before.
Well, ma'am, nobody can make you get a lawyer, but if you go talk to a lawyer, maybe you can come up with a defense that is going to, be successful.
Okay.
Okay, so I guess I probably need to set a final pretrial and trial date, huh?
Your Honor, do we have permission to supplement our motion for summary disposition and renotice it at the next pretrial?
Well, how is your argument going to be able to change? I mean, the fact is, look, the whole case is about, did she breach a contract to pay on this credit card, right? That's what the case is.
I want to supplement. I'd want our motion to be supplemented with the case law that shows that the requests for admitted are deemed admitted, and what I placed on the record in opposition to your ruling is the correct interpretation of the law. You have to rule in our favor based on that.
I do not. There's a fact question, but I tell you what, Mr. Bay, you can ask me to reconsider if that's what you're asking. File a motion for reconsideration. Obviously you have that right.
We do.
But I don't know. I think you guys just like spending time with me.
Well, you know I do,
Because
Judge.
you guys aren't trying to negotiate any kind of a settlement.
Try to.
No, they did not try to. They just wanted to get whatever money they can get from me. The stipulation, if I say paid in full, does not mean they can come back and get more money from me later. That's not right.
Wait, whoa. What do you mean? What do you mean?
They sent me this complicated document. I was willing to settle with them in the beginning.
Okay, well, ma'am, if you guys come up with a settlement, the case would be at best, it could be dismissed with prejudice because you guys can agree to that.
I don't, I do not.
Well, ma'am, I don't know what to do. I don't know what to tell you.
Well,
I don't know what to tell you.
They're so rude to me. I like, try to.
Ma'am, I don't, now look, maybe you need to be talking, maybe you need to file something in federal court if they violated the federal debt collection law.
I could see myself representing myself there.
Ma'am, I have told you this on more than one occasion, and I feel like it's pointless to say it again. Okay? You are making some arguments that may have merit, but you have to be able to connect the dots. And show how it applies to you. You haven't done that, and you won't go get an attorney. So, because you want to represent yourself.
Well, an attorney would.
So that's where we are. So, we'll have to have a trial, and it'll probably take a long time. But
an attorney wouldn't be able to produce any objective evidence any more than what I'm telling you.
Well, I disagree with you on that.
But how would they be able
I couldn't, in fact, I'll go even farther. I disagree a whole lot with you on that point. Because there are attorneys who practice in just this area of the law. I mean, ma'am, here's what I don't get. You've done research about some of these different cases that have been filed against these folks, right?
Yes.
So why would you not just call or contact the attorneys that sued them?
They charge $500 an hour, don't they?
Did you contact any of them?
Yes, I spoke to the attorney in legal services.
Ma'am,
Yes,
listen to me. Listen, you wouldn't want to call an attorney that does adoptions of children on a debt collection case. I mean, if I was looking for a lawyer on a debt collection case, and if I'd done the research like you had to see all the different lawsuits that have been brought against them for violating the debt collection laws, et cetera, I would be trying to contact attorneys that successfully sued them. That's what I would be doing.
So then they just want you to go
But
back.
you want to represent but you choose to want to represent yourself. And I think you're doing yourself a disservice. But that's, you know, I think you're doing yourself a disservice.
Why should I go?
That's all I'm going to say. What's that?
Why should I go the bankrupt when I've been a loyal customer?
I don't. Filing bankruptcy is a completely different situation, man.
Well, that's what they'll just tell me to do.
I don't know. Maybe they will. Maybe that's the solution.
And I have
no idea.
The times in the past and in my
ma'am,
60s.
I got to move on. Ma'am, I'm moving on. I'm going to adjourn, set it for final, have the clerk set it for final pretrial in 60 days. If you guys want to negotiate, that's fine. No, I think I'm done speaking in this hit.
Okay.
I'm going to set it for final pretrial.